Good morning everyone, a warm welcome to all for the 20th session of INN's Advocate. INN's Advocate segment is exclusively for advocates who are in practice less than 5 years. In this segment, advocates of their topic do their research and present them in front of our audience. So without wasting more time, I would like to call our today's guest, Advocate Sarjana Pandey, who is going to enlighten us on her research topic, that is an overview of Article 370. So let's welcome Advocate Sarjana Pandey. Now I would request our founder, Rahul sir, to felicitate our today's guest with Tulsi plant.
Especially thank the team of Hammurabi Tablet for having me here today. The topic I am discussing today is one of the most debatable topic right now in India, and not only in India but even internationally. Everything is revolving around Article 370, the state of Jammu and Kashmir and the government of India. Now, without politicizing the matter, I would like to focus more on the legal aspect of this matter, and for forming an opinion on Article 370 or whatever is happening or is right or wrong, whether the abrogation of Article 370 is constitutional or not constitutional, something which is very important to understand is the history of Jammu and Kashmir. The history of Jammu and Kashmir, as well as how the state acceded to India, the instrument of accession signed by the Maharaja of Jammu and Kashmir with the Indian government, or the Constituent Assembly which was formed to form the constitution, as well as to form the Article 370. With the antecedent, with all of these antecedents, we will focus on what's happening in the current scenario. For this, I will take you back to the historical background of Jammu and Kashmir. Jammu and Kashmir was an independent state in itself in the British era, and which was functioned under the Government of India Act 1935. Now, after the independence of both India and Pakistan, all the princely states in the country had to choose which state they'll opt for, which they want to go in. Now, Jammu and Kashmir being a Muslim majority state, having an Indian ruler, the Hindu ruler, it wanted to stay a separate and a neutral state, but which became impossible for them because some of the regional, western provincial regional raiders, attacked Jammu and Kashmir with the help of the Pakistani army and started raiding the state of Jammu and Kashmir, stealing things and murdering people, abducting women and raping women. So to save themselves from themselves, Maharaja Hari Singh, he decided to accede the state with the Indian state. Now, after signing the instrument of accession, the major point was that there are clause 4 to 9 which stated that the state of Jammu and Kashmir will be a sovereign state, but will be in the form of a federal state with the Indian government. And the Indian government is barred from making any state legislature or having any legislative authority for forming laws for the state of Jammu and Kashmir till the time the relationship between both the countries well defined. Now, owing to this, the formation of a constituent assembly was done. The entire formation of the Indian constitution was done by the Constituent Assembly, and this task of forming the special article which was defining the temporary article which will define the relationship between Jammu and Kashmir and India was given to Mr. Iyengar, Mr. Gopal Swami Iyengar, who was formerly also the Diwan of the state of Jammu and Kashmir, who was appointed by the Maharaja himself. Now, while forming the 370, the article would regulate the temporary relationship between India and Jammu and Kashmir, but it would also focus on the points which was not considered in the accession. At what laws and regulations would come under India, and which one would be excluded from the Indian state. So for this, and this would have obviously would be done on a temporary basis until and unless a separate constitution of Jammu and Kashmir is formed, and for which the Constituent Assembly had to be appointed in the state of Jammu and Kashmir. Now, the Iyengar's exposition of Article 370 in the Constituent Assembly was on October 17, 1949, where he authoritatively stated that we have also agreed that the will of the people through the instrument of Constituent Assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. Now, here the entire process of how the relationship would function would come under Article 370, that is the list of articles or the list of things which would be seen by the government of India, and especially the government of India was only obliged to take decisions pertaining to defense, communication for Jammu and Kashmir, which excluded the financial emergency that the state cannot, the state of India cannot pass a financial emergency for the state. Now, going ahead with this, the Iyengar explained that the provision is made when the Constituent Assembly of the state has met and taken the decision both of the constitution for the state on the range of federal jurisdiction over the state. The President may, on the recommendation of the Constituent Assembly. Now, after the Constituent Assembly of the state has been formed, the Constituent Assembly would decide the relationship between the state in a well defined manner, and after it is done, the Constituent Assembly will inform the same to the President of India, and the President of India would through an order of Article 306, that is the draft of 370, shall would state that the operation of 370 ceases to exist, okay, making the Article 370 an invalid act or not operative per se. Now, the Jammu and Kashmir Constituent Assembly was constituted in September 1951 and dispersed on January 25, 1957. The constitution was adopted on 17 November 1956, but it came into force in January 1957. Now, the Constituent Assembly had this resolve the head of the state being the Sadr-e Riyasat who would be the head of the state of Jammu and Kashmir. Now, Sadr-e Riyasat would be elected by the Legislative Assembly for a period of 5 years and would be functioning on the recommendations or the advice of the Council of the Ministers. And the eligibility of the Sadr-e Riyasat would be that he should be a permanent resident of the state of Jammu and Kashmir, and once the elective assembly appoints the Sadr-e Riyasat, he has to be confirmed and recognized by the President of India. This was the normal process of appointing the head of the state. So, for those who do not know, the state of Jammu and Kashmir until 1965 had two posts in who would rule the state, that is the Sadr-e Riyasat and the Prime Minister. The state of Jammu and Kashmir had its own Prime Minister until 1965, after which the same was exchanged, both the terms were exchanged with the Sadr-e Riyasat would be the governor and the Prime Minister would be the Chief Minister of the state. So, this was the major recommendation was done in under the Article 96, saying that the state government means to be elected by Sadr-e Riyasat acting on the aid and advice of the Council of Ministers of Jammu and Kashmir. Now, the Jammu and Kashmir Amendment Bill was brought in 1965 by the then Congress government, which replaced the positions of the Chief Minister, Prime Minister as the Chief Minister and the Sadr-e Riyasat as the Governor. Now, the 6th Amendment of the Jammu and Kashmir Constitution here forms the main role in all of this entire situation. The 6th Amendment to Jammu and Kashmir Constitution, carried out in 1965, made a fundamental change to the basic structure of the Constitution. Now, as per section 147 of the Constitution of Jammu and Kashmir, an amendment is to be assented by the Sadr-e Riyasat after a bill is passed in both the houses, and majority of the whatever the majority is, the state will amend it accordingly, and without the assent of the Sadr-e Riyasat, it won't be a bill, and after that we will be going to the President for its assent. So, this is as how in India it is, that the bill is produced by the government and introduced in both the houses, and then with the majority bill it passes and goes to the President for the assent. So this was the basic structure. Now the section 147 of the Constitution of Jammu and Kashmir itself has a provision which states that the 147 cannot be amended. So the amendment article of Constitution of Jammu and Kashmir itself cannot be amended. So now Sadre Riyasat was however replaced, as I told you, across Jammu and Kashmir constitution except only this part of the section 147 of the constitution, which could not be amended obviously because it had that proviso in it that this shall not be amended. Now as this happened, the Sadre Riyasat as well as the governor in 1975 from a presidential order issued by the president under article 370 barred the Jammu and Kashmir state legislation to make any rules which will take away the powers of the governor or would make any such changes that would not affect to a change and take away the power of the governor from making any rules in the state. So in December now pertaining to the entire situation as to the 6th amendment in 2015 when the new coalition government was formed, the matter went to the High Court of Jammu and Kashmir on the matter in the case of Abdul Khayyam Khan versus the state of J&K, which discussed this in length that whether the removing of Sadre Riyasat, governor being the Sadre Riyasat is valid or not. So in this the so the governor was whether the state head as governor is constitutional or not constitutional. Now the High Court stated that the status, the elective status, like as under the Constitution of Jammu and Kashmir, the Sadre Riyasat is to be appointed and elected by the state legislative, and in that state legislative means the people elected by elected by the people, the government, and then he'll be appointed by the state legislative. Now the court said that the elective status of the head of the state was an important attribute of constitutional autonomy enjoyed by the state, a basic framework of the state constitution, and therefore not within the amending power of the state legislature. In terms of the aforestated amendment, the governor is appointed. Now in the recent cases, government is appointed by the president and not by the state over here in Jammu and Kashmir. So by the president and is to be head of the state. The office of the head of the state is in wake of the amendment ceases to be elective. Now as per the normal process in India, the governor of any state is appointed by the president himself. So the basic structure what the Constitution of Jammu and Kashmir had, that the governor is appointed by the state legislature, but in this case now in India the president appoints the governor. So the elective part of the Constitution, which is a very basic principle which contains the in the Constitution, is violated because it's not constitutional to say that the head of the state would be appointed by the president itself. Now the 6th amendment did not only merely change the nomenclature of the act, but also the eligibility process of how the governor or the Sadre Riyasat or the head has to be appointed. Now let's come to the current scenario. On 5th August, the Home Minister introduces the President Order, the Constitution application of Jammu and Kashmir Order of 2019 under Article 370, superseding the Constitution application to Jammu and Kashmir Order of 1954. Now the order stated that all the provisions of the Indian Constitution would be applied to the state of Jammu and Kashmir, whereas the 1954 order, which was passed by the President, enumerated only a specific list of provisions which would be governed by the Indian Constitution. Now the new order removed all the restrictions. This is in effect means that the state of Jammu and Kashmir is like other states of India. Now it merges all the special statuses goes from the state and the Constitution stays abrogated. Now the main part what people here say is that the Article 370 has been removed. It's not been removed, it's being a myth. The Article 370 has been abrogated, it's been used to finish the article itself. Now the presidential order of 2019 also added a clause 4 with 4 subclauses to article 367 which states the interpretation. So now the phrase Sadre Riyasat on the aid and advice of Council of Ministers shall be construed as the government of Jammu and Kashmir. Now also in the interpretation clause, the phrase the state of Jammu and Kashmir also includes the governor. Now in the proviso of clause 3 of article 370 of the constitution, the expression constituent assembly of the state, who was supposed to take all the decision pertaining to the state and whose advice was necessary for the governor to take to make any amendment and then pass to the President of India, the Constituent Assembly of the state has been referred in clause 2 shall lead to legislative assembly of the state. According to the constitutional experts, they say that the 370 has been issued since 1954 in similar circumstances when the state was in president rule. Now under the state government the union government interpreted the concurrence of the state government under these circumstances to mean the governor. Now the state, as the machinery fails, as you know that the government of Jammu and Kashmir collapsed, so the president rule came into picture and the president appointed the governor as to be the head of the state. Now after this interpretation, it is now that the state, the governor would also be is also equivalent and also be the governor of Jammu and Kashmir, and hence as having the power of the head of the state as well as the power of the legislative assembly of the state, the governor issued an advice to the president to remove article 370, and the president on that order issued an order removing article 370 from the picture and taking away the special statuses and amending 370 itself. Now immediately after the presidential order was placed, the Home Minister also moved a resolution recommending that the president issue of the order to be order under article 370 rendering all clauses of 370 to be inoperative. After the resolution was adopted by both the houses, the president issued a constitutional order 273 on 6th August 2019 replacing the exact text of the 370, which reads as all provisions of this constitution as amended from time to time without any modification or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in article 152 or article 308 or any other article of this document. Now judgment, ordinance, order by law, rule, regulations, notification, customs or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under article 363 otherwise. Now let's come to the ongoing debate which is happening on the abrogation of 370. Now since the presidential order has made with the approval of the governor and not with the government, the fundamental questions arises was whether the government was having the power to do so. Now for that we would see that article 371D, now people would say that article 371D gives the power to the governor to make laws pertaining to the state. Now we have to focus the main thing that whether this was correctly interpreted or not. It always comes in the end to the way how the article has been interpreted. Now we'll focus more on how the Supreme Court has stated the entire thing. In 1970, in the case of Maqbool Damu versus State of Jammu and Kashmir, the Supreme Court stated that the Constitution of India and Jammu and Kashmir in their original form has designated a position named Sadre Riyasat as to the state of Jammu and Kashmir. Things changed when the Constitution for the state through its 6th amendment replaced this position with that of the governor. Now thereafter, to make things consistent, a presidential order was made in agreement with the governor under article 371D. Now deciding on the legality of this order, the Supreme Court has ruled that the point was a valid point and the amendment of the constitution of the Jammu and Kashmir strictly strikingly said that the different from the current presidential order where no involvement whatsoever of the state legislature was there. Like at that time when this judgment came, there was an existence of a state legislature functioning, and what the governor ruled or the governor's order was just in a clarificatory form rather than right now changing the entire status of Jammu and Kashmir. So also, if the major point being that whether the constitutionality of this article is to be questioned on what basis, that whether the state legislature was absent, the state mechanism was absent in the state, and the governor was appointed by India itself, and the governor without having any advice from the council of ministers or having any advice or taking any decision from the people elected representatives, and without any of these considerations, the governor himself orders something like abrogation of 370 and advises the president to remove it, and the president then orders the abrogation of article 370 by the constitution amendment orders, the constitution of Jammu and Kashmir amendment orders. So whether this is the correct thing to do, like it's article 370 is a very good abrogation of article 370 is a very good measure which is taken by the government. Like it will give a lot of opportunities for the people of Jammu and Kashmir, and as well as the Indian people to venture more and invest more there. The people would have the same rights. The entire country would form will have only one constitution, and people would be relying more on each other than this. But whether the process and the way was correct or not, whether the people's assent is important in this or not. Now as for the government side, that people would say that it's unconstitutional, should also think that the president had this power to make whether he had this power to make this order or not. Now as per the constitution, article 356, as people say that article 356 is when the provisions case of emergency in where the president rule applies, where there is a absolute fail of state machinery. So here, as we see that from November 2018 there is no government functioning in the state, there was a presidential rule, and as per that the president appointed the governor who was the head of the state, and then as per the provisions, the president has the power to take any orders or make any orders or any rules pertaining to the state where there is an emergency, bring the order between to both the houses, and pass the order accordingly, because the parliament has then the power to make the rules for that state. So if we see, the legality of 356 also is here, which supports the government that what process they followed was also correct, because there was a presidential rule. But then again, the most principal thing which comes is whether these people of Jammu and Kashmir had a say in it or not, whether for their good or for their bad. So which was very important as a democracy. That is something which has to be taken care of, that even the government should have said that 370 is so good for you all, it would do good, but are you all willing to do it or not? Are you all giving a assent so that we can go ahead with it? So summing up the entire session, I would just come to the conclusion that the abrogation of 370 is undeniably a very bold step by the government, which will help Jammu and Kashmir, but to streamline with the entire nation, like how it was stated as something different. Jammu and Kashmir was something different from the entire state, but bifurcation of it into three parts, or without taking into consideration the views of the people of Jammu and Kashmir. If the view of the people were taken, this could have been a tremendous success, both domestically, internationally. People would have applauded India for taking such a bold step, and taking the people with them, and the whole entire, the biggest and the largest democracy of the world would be true for India. So that's all. Thank you so much.
Thank you, Sarjana. It was a very nice to hear all the concepts, the history, and first of all, I would like to congratulate you, because you have taken such a topic which is in very hot debate, not only in India, but it's an international topic which is going on. So once again, thank you very much for giving us this nice lecture and overview of Article 370. Now, we will like to present you a memento from Hammurabi Tablet. And thank you being a part of Hammurabi Tablet.
Thank you.